Now it's my pleasure to introduce Professor Miriam A. Cherry. Professor Cherry is the Associate Dean for Research and Engagement, Co-Director of the Weffel Center for Employment Law, and Professor. And with that, I'll turn it over to Professor Cherry.
Thank you so much, Mike. As Mike mentioned, this is the first of a 3-session webinar series. Today's webinar focuses on the labor and employment law issues that have arisen during this pandemic. Employment is an especially important issue because of some critical trends occurring in the economy. During April of 2020, unemployment rates hit highs of 14%, and state unemployment offices found themselves overwhelmed with unemployment filings. At the same time, safety concerns have seen many businesses turning to remote work, and workers have been using more technology on the job. This has created both opportunities but also challenges, as the panel will discuss. We are fortunate to be joined today by experts from the Weffel Center for Employment Law at SLU Law. The Weffel Center is home of the ABA Labor and Employment Law Journal and helps to connect students, practitioners, and academics focusing on the study of labor and employment law issues. These talks were pre-recorded so that we could make sure to get the most information possible into the 10-minute time frames for the talks. Then, as Mike mentioned, we'll have time for questions, which you can enter into the chat. So first, we will hear from Professor Matthew Bodie, who is the Callis Family Professor of Law and the co-director of the Weffel Center for Employment Law. Professor Bodie will speak to us about employee privacy in the pandemic, testing, tracing, and disclosure. His presentation will cover the issues around employee privacy in the pandemic, including rules that govern testing of employees, contact tracing, and disclosure of this information. From there, we will turn to the presentation of Professor Ruqaiijah Yearby, who is a member of the Weffel Center for Employment Law, a member of the Health Law Center, and who serves as the Executive Director for the Institute for Healing Justice and Equity at St. Louis University. Her presentation is entitled Structural Discrimination and Essential Worker Protections. Professor Yearby will discuss workers such as those in healthcare, agriculture, and meat processing who have suffered from heightened rates of infection in this pandemic, and most of whom are low income, disproportionately female, and minority. OSHA has an obligation to protect workers, but the agency is not effectively enforcing these laws. And some states have passed laws limiting employer liability. And at the end, her presentation covers possible solutions. Finally, we'll end with my talk, Gig Workers as Essential Workers. My presentation covers the issues faced by workers in the gig economy during the pandemic. Gig workers such as Instacart shoppers and DoorDash delivery drivers have been considered essential workers under numerous state laws, and they've been vital to getting food, medications, and transportation to those who need them during this critical time. My presentation argues that these workers have thus earned parity with traditional employees, despite the continuing legal issues around employment classification in the gig economy. So with that introduction, let's get started with Professor Bodie's presentation.
Hi, my name is Matt Bodie, and I am a professor and also co-director of the Weffel Center for Employment Law at St. Louis University School of Law. Hope you're doing well, and I'm happy to talk to you today about employee privacy in the context of this pandemic, particularly with respect to testing, tracing, and disclosure programs. So let me get started with my PowerPoint. All right, so what are testing, tracing, and disclosure programs? Essentially, the purpose of a testing, tracing, and disclosure program is to find out who has the disease, determine who they've been in contact with, and make sure those folks know that they have been in contact with someone who is contagious with the coronavirus, so that they can take steps such as quarantining or isolating to prevent the further spread, right? These programs are in place in a number of countries internationally. However, our country does not have any federal plan in place. There are some states and localities who have versions of a testing, tracing, disclosure plan, but those have not been comprehensive and have not been significantly funded. So we are left with employers as a possible vector for doing the work of testing employees tracing to see who those employees have come in contact with, and finally, disclosing to those that have been in contact with these employees to make sure that they know what the potential is for their own contagion. All right, so let's start first with testing. So temperature checks are one way of testing, as are the actual coronavirus tests themselves. Temperature checks have the advantage of being immediate. You can tell right away if someone's temperature is higher than normal. But as we know, they are not sufficient to test and determine everyone who might have the virus because there are a number of asymptomatic carriers out there. The problem with coronavirus testing is that it can take up to 2 weeks to get results back under the current environment. So most employers will have some mix of those testing programs. These testing programs are medical examinations under the Americans with Disabilities Act. And therefore, the employer needs to meet certain requirements in order to conduct these examinations on employees under the ADA. Now, the pandemic does meet the direct threat standard. Let me just read to you a little bit what the direct standard says, direct threat standard. It's a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodations, right? So the EEOC has said, because of the pandemic, employers can test under the ADA. Now, employers need to be careful when they ask questions about whether employees are particularly susceptible. For example, are they immunocompromised? Or if employers ask employees about whether they have conditions that might make the illness more severe if they were to contract it. There's been some evidence that diabetes, heart disease, high blood pressure make the coronavirus more severe for a number of folks. So the EEOC says, well, if you're going to ask that kind of question, you have to be careful. You have to put it in with a number of other questions that are non-disability related, so that when the employee answers, it could plausibly be about something else. So for example, do you have a condition that might make you more susceptible to the disease? Should be paired with a number of other questions, including, for example, do you take public transportation? Things that make one more likely to get the disease need to be put in a disability and non-disability set of questions. Now, the answers won't be as satisfying because they'll be more ambiguous, but that's what the EEOC is asking employers to do at this point. All right, HIPAA is not the general duty, no one can share any health information ever that a lot of folks think it is. It's just not that kind of a statute. The employer doesn't really have any duty under HIPAA to protect health information. The one area where it may come up in the testing program is if the employer wants to get testing information from a testing provider, so a healthcare provider. The employer can only get that information if the employee consents, and that's what will happen in most cases. There are also two other ways, or two other exceptions that allow the healthcare provider to provide the information to the employer. Those will not likely come up all that much, but we do discuss them in our paper. I've written a paper with Michael McMahon on this topic. I have a slide at the end with some information about how you can find that paper, but we go into much more detail there. All right, let's talk about tracing. There is no general employee privacy statute that says that employers can't monitor their employees or that employers can only monitor under certain circumstances, right? So generally the rule will be that employers can monitor their employees, can trace their movements. HIPAA does not apply here, right? There's no protected health information. And as we mentioned earlier, it just doesn't generally apply to employers. The Electronic Communications Privacy Act will likely not apply here either. Most tracing programs will not involve an interception. There has to be an interception for ECPA to kick in and prohibit the activity. And there's just generally not going to be interception involved with the technology for the most part. Also, if the employee consents to the tracing, then that will take care of the ECPA problem as well. There are some state laws that employers should be aware of that require notice or consent to monitor in California, Connecticut, and Delaware. Also, if the employer wants to do a comprehensive tracing program that includes off-duty tracing. Off-duty activity laws in a number of states may come into play if the employer, for example, says, well, I don't want you to go into a bar. The employee goes to a bar, the employer fires that employee because of the tracing. They know that the employee went to the bar. Under those circumstances, that might run afoul of the off-duty activity. But most employers are probably likely to have in their tracing to the workplace during working hours, just because it's too much to ask employers and it's too invasive of employees to have a 24/7 monitoring program. If the employer is too intrusive with the tracing, that may also call up tort liability under the privacy tort intrusion upon seclusion. All right. The third step is disclosure, letting people know that they've been in contact with someone with the illness. So OSHA has stated that there needs to be notification if an employee tests positive to other employees, right? And local health authorities also want to know about positive tests as well. The Americans with Disabilities Act says medical information should be kept confidential. So how do we square these two things? Right. Well, there is a pandemic exception to notify other employees and also to provide notice to public health officials. So hopefully that should take care of disclosure, although it does leave customers out a little bit up in the air, right? Can we notify customers? Yes, you can if the employee's identity is kept secret, right? If you say one of our employees tested positive, we have reason to believe you were in contact with that employee, that's a way of protecting the employee's identity while still getting that information out, right? That anonymity may not be foolproof. The customer may be able to figure it out, but under the circumstances, this is a balancing of the public's need to know, customers' desire to know, with the employee's desire of keeping their diagnosis private. Under some circumstances, if the employer does in fact share that a particular employee reveals the identity and lets either the public know or even just fellow employees know, there is possible tort liability under those circumstances. The public disclosure of private facts tort does apply to coworkers in some jurisdictions under the special relationship doctrine. So keep that in mind. Data security here is really important. We want to make sure that people's identity is protected and their any medical information related to them is kept protected. Every state has a data breach notification, and so if there is a breach, you need to inform under certain circumstances. But regardless, if the employer is sloppy with the data or an employee, decides to tell a lot of other people that someone has come down with the virus or is tested positive for the virus, that could really incur liability under tort law or under certain data breach notification laws or data security laws. So, all right, employer best practices, clear notice to clear notice to workers about what is expected from the employees, what sort of program is going to take place, how that information will be collected, what information it will be, how the employer is going to use it. The more information about the program, it's good not only for employers to let employees know what's going on, but employees then have some more peace of mind that they're being looked after in terms of their coworkers' possibility of illness, right? No one wants to get the illness from a coworker. No one wants to pass the illness on to a coworker, right? So these programs are designed to protect employees and they don't need to be adversarial. But limit sharing on what is necessary to know. Don't let a lot of people know, particularly the identity of the employee beyond a very small group that's designated for that purpose. Use anonymous disclosure whenever possible, and of course, data security. All right. I'm going to close with a citation to the paper that I've written with third-year student Michael McMahon. It's available for free on Social Science Research Network. The link is there. Really hope that you enjoyed the presentation, and I am going to sign off. Thanks for watching, and stay safe out there.
Hello, my name is Ruqaiijah Yearby, and I am a professor of law and member of the Center for Health Law Studies at the St. Louis University School of Law. I am also Executive Director and co-founder of the Institute for Healing Justice and Equity at the St. Louis University. Today, I will be discussing structural discrimination and essential worker protections under COVID. COVID-19 is not the first time that we have seen disparities in infections and deaths, particularly among racial and ethnic minorities. Dating back to the 1918 flu pandemic, American Indians experienced a disease-specific mortality rate of 4 times that of other ethnic groups. This was repeated during the 2009 H1N1 pandemic. And during COVID-19, we see that the Navajo Nation actually has more infections than the state of New York. But these disparities are not a result of any genetic factors. They are related to structural issues. In 2008, Blumenshine hypothesized that racial and ethnic disparities in infection and deaths during pandemics were actually linked to structural issues that cause disparities in exposure, susceptibility, and treatment. In particular, disparities in exposure were linked to employment practices, such as the lack of paid sick leave, the lack of worker protections, and disparities in susceptibility, pre-existing health conditions were also associated with structural issues in the workplace. Today, I am going to be discussing structural discrimination, and it's linked to disparities in essential workers' infection of COVID-19. Particularly, structural discrimination is about the ways that our systems are structured to advantage the dominant groups, while also disadvantaging racial and ethnic minorities. It produces differential conditions between these dominant groups, here whites and racial and ethnic minorities, leading to health disparities. Law is one of the tools used to create these differential conditions by structuring systems in a racially discriminatory way. So either law is used to create differential conditions, or the lack of enforcement of laws results in differential conditions. There's no bad intent required, and it is often couched in neutral terms. When we look at COVID-19, essential workers are defined differently across states. But what is clear is that a majority of the essential workers come from 2 groups. The healthcare industry, about 30% come from there, and 21% come from the food and agricultural industry. As a result, it is not surprising that a majority of these workers have been infected and died. Over 41,000 meat processing workers have tested positive, and 193 have died. More than 139,000 healthcare personnel have tested positive for COVID-19, and 642 have died. A majority of these workers are low income, racial and ethnic minorities, and women. Also, we see agricultural workers being impacted disproportionately by COVID-19. And in fact, agricultural workers at a pistachio farm in California didn't even know that a worker had tested positive until they saw it on the news. Why is this a problem? Because OSHA is supposed to protect workers. In particular, OSHA in 21 states that have OSHA-approved plans have the power to require employers to provide employees with protective equipment, so PPEs, and to develop a respiratory protection standard to prevent against occupational disease. Furthermore, under the law, employers have a duty to provide employees with a place of employment free from recognized hazards that are causing or likely to cause death or serious harm. Unfortunately, these laws have not been enforced by OSHA rigorously during the COVID-19 pandemic, and that's why we see an increase in infections and deaths of essential workers during this time. Furthermore, even if they did, there's still some gaps in these laws. These laws actually do not require employers to do a hazard assessment plan and to track infectious disease. There are other problems with OSHA's response. OSHA has worked with the CDC to issue advisory guidelines for employers and employees. Some of these guidelines suggest that workers remain 6 feet apart, that they are provided with protective gear, PPEs, that there's increased hand washing. The problem with these guidelines is that they are not mandatory. So unlike the laws that I discussed prior to this slide, the general duty and the requirement for a respiratory standard, these guidelines are not mandatory. Furthermore, they do not require testing. But mandatory testing of all workers after identification of an infected worker is necessary to track worker infections, as well to prevent the spread of COVID-19, as many people, including essential workers, are asymptomatic and can spread the disease. Furthermore, many of these guidelines were issued late. In fact, guidance for agricultural workers was not issued until June 2nd, 2020. But by mid-April, agricultural workers were already experiencing increased rates of infection, COVID-19 infection and deaths. By the time the guidance was issued, over 2,000 agricultural workers in New York, almost 2,000 in California, and over 1,000 in Illinois, Texas, Iowa, Washington, and Minnesota were affected with COVID-19. Moreover, OSHA has said, even when it does have mandatory bylaw requirements to enforce laws such as the general duty, that it would only make a good faith effort. It would not conduct in-person inspections, only requiring employers to make a good faith effort to comply with the law and the advisory guidelines. As a result, many workers have filed lawsuits against OSHA, trying to get them to enforce the laws. Furthermore, congressional representatives from the Democratic Party and the Republican Party have asked OSHA to issue emergency temporary standards that would apply directly to COVID-19 infections within hotspots and hopefully protect all essential workers. To date, OSHA has not done that. So we see a gap not only in worker protections, in the enforcement of the laws, but we also see it with the enactment of several business liability laws. Alabama, Iowa, and Oklahoma have passed laws that have limited the ability of workers to actually receive compensation for contracting COVID-19 at the workplace. North Carolina, Utah, and Wyoming have also done this, but left in place worker compensation laws that can provide workers with health care and money to be able to take care of themselves during COVID-19. Now, why is this an example of structural discrimination? This is an example of structural discrimination because the lack of enforcement of OSHA laws, the general duty and respiratory illness protections, the failure to do in-person inspections, and the failure to provide for workers' compensation means that essential workers who are disproportionately racial and ethnic minorities, poor, and women are left without any means to protect themselves after they are exposed to COVID-19. So what are some solutions? OSHA should publish a final rule based on the proposed airborne infectious disease to ensure the protections of these essential workers. It needs to make complaint data public, conduct in-person inspections, and mandate testing for all workers. Furthermore, we need to protect workers by ensuring that we expand workers' compensation, that we partner with community groups for testing, and that we provide them with paid sick leave, hazard pay, and life insurance. If you have any questions, please feel free to look at some of these articles that I have written, and I look forward to answering your questions. Thank you.
Welcome. My name is Miriam Cherry, and I am the co-director of the Weffel Center for Employment Law here at SLU Law. So today, I'm going to be speaking with you about gig workers as essential workers during this pandemic. So in order to really understand the context of what's been going on, I wanted to talk more about the debate about gig workers and their status either as employees or independent contractors. So many of you are familiar with these issues, these legal issues. There's actually been litigation over the past decade about whether gig workers working on platforms like Uber and Lyft, Instacart are employees or whether they're independent contractors. And actually, I recommend an article to you that I wrote back in 2016, which is called Beyond Misclassification, the Digital Transformation of Work in the Comparative Labor Law and Policy Journal. And there I discuss some of the issues, why it is that this has been such a difficult problem to figure out. On the one hand, there's a lot of flexibility that gig workers have in order to figure out the hours and precise details of their work. On the other hand, there's a serious amount of control that the platform is able to exert on workers because of algorithms and being able to track through GPS exactly what the workers are doing. So this definitely has created some concerns and problems for trying to figure out the precise status of these workers. And in fact, that in just the last year, this has not been an easy question to figure out, and there's been conflicting information and guidance. So for example, the NLRB issued an advice memo that said gig workers were independent contractors for the purposes of collective bargaining and organization. However, in around the same time period, a case, Razak versus Uber from the Third Circuit Court of Appeals actually reversed a district court that had said that Uber drivers were independent contractors, and in fact seemed to lean in the other direction and imply that the holding would eventually be that these workers would qualify as employees. And California has passed AB 5. This is Assembly Bill 5 changed the test for trying to determine employee status in California, and in fact means, because they've moved to the ABC test, which is a test that enables more people to be found as employees. And so Uber and Lyft are fighting this on the November election, this coming November, with a ballot initiative. So there's definitely conflicting guidance and confusion about the status of gig workers. Now, what does that mean when we get to the pandemic? Well, if employee status is unclear or seems to be an independent contractor, then that could preclude gig workers from claiming access to traditional employee benefits, such as minimum wage, overtime, discrimination, but perhaps most importantly for the circumstances of the pandemic, would also prevent them from claiming unemployment insurance or paid sick leave. Now, this is very problematic from a public health standpoint. Why is that? Well, several studies have shown that workers who lack access to paid sick leave are 1.5 times more likely to work sick. And in the context of the pandemic, this is especially concerning because of that possibility for asymptomatic contagion, or even contagion when people are sick. So this issue is compounded for gig workers because they're typically paid only if they work, and they're paid by the task or by the job. And even in states that do mandate requiring sick leave, that's not all states, but many of those laws where there are laws apply only to employees. So again, this question of status matters for access to paid sick leave days. Now, turning to gig workers during the pandemic, we've seen during the pandemic that actually Americans have been heavily reliant on gig workers to perform some of the essential services that they need while they were in lockdown. That includes meal delivery, grocery delivery, medication, and the delivery of other goods to their homes. Now, as such, we also have to take into account the definitions for essential worker. And states, this is actually state definitions, but they pull on federal guidance from the Cybersecurity and Infrastructure Security Agency, the CISA guidance. And so states like Georgia and Texas have adopted the CISA guidelines. And they talk about delivery food workers, delivery services, car sharing services, and transportation network providers. Those are rideshare companies that are gig companies. And they are defined as essential workers that are exempt from lockdown. So they're deemed extremely critical to being able to maintain people's health and safety. Other states, like Alaska and Colorado, use language that implicates gig workers in their definition of essential workers. So they talk about those that offer food and beverage using delivery service. And other states, such as Indiana, Hawaii, and California, come the closest to mentioning gig workers directly. They talk about businesses that ship or deliver groceries, food, goods, vehicles, alcohol. And they talk about transportation network providers, such as Uber and Lyft. They actually mention them by name as being essential workers. And the companies themselves use this language to describe the status to their workers. So they say, right, DoorDash says, deliveries from restaurants and grocery stores have been deemed essential services. That means Dashers may continue to perform delivery services. And Uber says you are doing essential work. So what does this mean? It means that gig workers are risking exposure to disease as essential workers. But at the same time, they were being denied access to some of these most basic employee benefits because of the legal question of their employment status. Now, this is changing, and this is in fact where the CARES Act comes in. So provision of the CARES Act have created the Pandemic Unemployment Assistance, the PUA program. And the PUA allows people, individuals who do not qualify for regular unemployment compensation, to now be eligible for unemployment benefits because of the coronavirus pandemic. So there is a silver lining here. The PUA brings gig workers closer to parity with traditional employees, granted only for a limited time and under limited circumstances. But it does do something for workers who can show that they've been laid off because of the COVID-19 pandemic. Now, there are some limitations. So unemployment systems, some of the state unemployment systems require the gig workers to file, be rejected under the traditional system, and then file again for PUA benefits. And some gig workers have complained if they work a traditional job and then they work additional hours as gig workers, that they haven't been able to access that additional money. They've only been able to get unemployment for the W-2, the regular job that they had. But that being said, most states at this point, despite long wait times, have been able to process those PUA benefits for workers. And they're eligible for up to 39 weeks of benefits. And so granted, even though there are all these caveats and it's temporary, the PUA may be a welcome sign of changes to come for gig worker access to various employee benefits and protections. That said, here's the other silver lining, potentially. The unprecedented nature of this pandemic has spurred some platform companies to offer their own version of paid sick leave to their workers. Now, that being said, while that's good, there have been some challenges, and gig workers have reported problems with getting conflicting information from companies or having to hound customer service agents in order to get what they're entitled to. And so Instacart and some other gig workers have created the Pay Up movement to try to get a better system for sick leave. Why is that? Instacart's paid sick leave program is actually very narrow. It only protects those who have tested positive for coronavirus or who are in quarantine under the direction of a public health agency. But that's problematic because it excludes workers who can't access a test or only have a doctor's note, or those who are waiting for test results. And so shoppers have complained about this. So in fact, taking a look at this, here are some statements from workers. So this is from an Instacart worker. I inquired about the 14-day coronavirus pay because I'd gotten tested and was waiting to hear my status. A few days later, I was deactivated from Instacart without pay. They say it was a health violation. Here's another comment from Instacart. I submitted every proof I could, including discharge papers instructing me to quarantine. But then they didn't do anything about it. And finally, here's a statement from an Uber worker. They sent me a link that didn't work. They said a doctor or public health official would have to log in. My doctor was frankly so busy she couldn't. We make Uber literally all of their money, and I can't even afford my insulin in the state of Texas. They couldn't even throw us a bone, right? So those are some of the things we're hearing. So just to come back to it and sum up, I think for a long time, the concern has been parity of coverage and protection for gig workers in comparison to traditional employees. And here, I think the case for parity is bolstered by this pandemic for two reasons. First, gig workers have taken on these frontline dangerous and risky jobs, and so they have earned parity. Second, I think more people, we're doing this webinar in a computer-mediated format, more people work on the computer now. They understand that there really isn't any difference between some of the work that people are doing in traditional employment relationships and those that gig workers are performing. So for those reasons, I actually think there are some silver linings to this pandemic for gig workers, and I look forward to continuing the conversation. Thank you so much. All right, so we've seen the videos, and I'm going to ask my fellow panelists, Professor Bodie and Professor Yearby, to come back on and join us now for the question and answer portion of our webinar. So I did have a few questions that people had asked in advance, and I'm going to go to those questions first. But please feel free to insert a question into the chat. We'd love to hear from you. And if it's directed to any particular panelist, please do note that in the chat. All right, so I'm going to start off with a question that was given to me for Professor Bodie. And the question is, what kind of new data is being generated in this pandemic that could potentially cause a privacy concern for either businesses or for workers?
Right. Well, thanks for that question. You know, there's just a lot more invasiveness into employee health, for one thing. A lot of employers are taking temperatures of employees or taking records as to test results for, obviously, the coronavirus. Those two are the most salient kind of items of information. A lot of employers are not actually recording any data about temperatures. They're basically taking worker temperatures, but then the worker has a temperature above a certain amount. They're asking the worker, they kind of set up a test station outside of the workplace or in an area that will allow the worker to basically not have the opportunity of being in touch with other workers. So it's kind of preliminary to going into work. You get your temperature taken if your temperature is too high. And we've seen this in all sorts of workplaces. I just was watching an NBA thing the other day where they had this set up for NBA players and NFL players as well. So all sorts of workers are having the temperature taken. That's not a foolproof test, obviously, but the actual tests themselves are take a number of days to come back, and so that's an issue there. I think the bigger question is, to what extent are employers going to use this moment to get even more involved with employee health? You know, I was just talking about professional athletes. Obviously, the intertwining relationship between athletes and the teams they work for in terms of the athletes' health is something that is incredibly, invasive for a lot of us. Athletes get used to it, and obviously they're compensated very well. And the idea there is to help them perform better, so they have an interest in that. But your average worker might not want the employer to come in and say, hey, what did you eat for breakfast? How are you feeling today? Right? But obviously, if I'm sick and I infect my coworkers or my customers or my students in this case, that would not be good for my employer. So I think that level of interest in health data, we've traditionally wanted to kind of separate health data from something that employers are involved with, but we're crossing the lines here, and I think that would be the worry going forward, is how are we going to manage that relationship?
Okay, great. Thanks for answering that. And I've also got a question for Professor Yearby, which is, could you elaborate more on what actions you think need to be taken to protect the safety and health of various essential workers?
So first, I think the main goal of OSHA should be to issue an emergency temporary standard. Right now, as I mentioned in the talk, they have the general duty standard, and they can require employers to provide personal protective equipment, but those still have many gaps. And so OSHA has been working on an infectious disease rule for a number of years, actually since about 2005, I believe. And so they could use that to issue an emergency temporary standard to address workplace issues. Mandating hazard assessments and plans to address COVID-19. And while they're doing that, then they can finish the final requirements for a rulemaking process. I think that, to me, is the first step for OSHA. Definitely getting mandatory rules. I think the second step is ensuring that they begin to conduct in-person inspections, and do so in a manner that doesn't let the employer know before they go in that they're coming in. We've seen reports of actually OSHA surveyors coming in and calling before, just to let the meatpacking processing facility know. that is not helpful at all. I would say the USDA, because they are in control of line speeds and other areas related to farm workers, that they revise their rules to ensure that it leads to increased safety standards for workers. I think that the last thing that I would say is that often with workers, essential workers, we only think about the workplace. But sometimes workers are in the workplace, even in their homes. So when you think of farm workers, many farm workers don't live initially on at the farms that they're working on. So they're given temporary housing, and that needs to be a part of the standards about workplace standards. And so you see certain states coming in and saying, no, we need to limit how many people are in these places and living in these places. And so I think that's another focus, that we need to ensure that if people are renting places from their employer, that those need to be safe as well.
Thank you so much. I've got a question here, actually directed to me, which is, could you elaborate more on, could you say more about the recent injunction in California to reclassify gig workers as employees and Lyft's threat to cease operations in California? So this has definitely been in the news, and even since the point at which the video was recorded, there have been many different changes that are going on, and it's a really dynamic area. And I've certainly been following the classification debate for many years. So you might have seen this in the news. This was just last week that the attorney generals of municipalities in California had actually tried to seek an injunction to get enforcement of that AB5 law that I talked about, which would reclassify the gig workers in the state as employees. And this is on the November ballot. And so Uber and Lyft's argument was, just wait until November and then we'll get an answer and we'll decide what to do at that point. But the AGs are not happy with that answer. They're seeing a lot of people who are out of work and not able to claim benefits, and a lot of complaints, and they say there's really no reason that there should be a continuing delay. So they want action on this now. And in fact, the California Supreme Court in 2018 in the decision Dynamex had first announced this ABC standard. And at that point, people were telling Uber and Lyft, you need to figure out how to comply with the law. It looks more like under this test that these workers are going to be employees. So, I think, and then in response, Lyft had threatened to pull out of the state, and they've actually done that before. In Austin, Texas, when they were being asked to conduct background checks, Uber had ended up leaving Austin. They've since come back, actually, and now they do the background checks. So it's definitely an interesting tactic. It's definitely an interesting back and forth. Right now, that injunction is being heard at the California Appeals Court. So there's a stay while that's being heard, and Lyft doesn't seem to be going anywhere. But stay tuned, right? That's kind of the next chapters. We're going to see that, and then we have to keep our eye on the November election in California, just like so many things that we're looking at. I have another question. This one is for Professor Yearby. What kind of changes need to happen to ensure that there is paid sick leave for essential workers?
And I might also ask Matthew to talk about this as well. And so one of the things really goes to what you were just saying, Miriam, right? Is that when workers are classified as independent contractors, sometimes they're not included in terms of paid sick leave. So I think that, one way that I think about this in sort of under public health emergencies is that we really need to tie public health emergency powers and laws and connect that with protections for essential workers. And so beginning to think about that if we are going to close down states and pass laws that say, well, if you're an essential worker, you can continue to go to work, that needs to be connected with some measure to say, here, we're offering you paid sick leave, perhaps some testing, perhaps also benefits and worker protection. So that's my thought, that we really need to revise our public health emergency preparedness laws and policies to link them to workers that have to continue to be out, not social distancing, and not staying at home. So those are my thoughts about essential workers, that we need to include that. I think that you can put in paid sick leave, worker protection laws, and maybe even workers' compensation for those particular workers.
Matt, did you have something to add?
Well, just quickly, we have a lot of tools out there. It's just a question of getting them to the workers. And particularly if workers are essential, then they should have quicker routes to getting testing. They should have access to PPE. They should, there should be more enforcement. It shouldn't be left to the worker at the front of the store to tell people, sorry, you can't come in if you don't have a mask. That's putting people in some physical danger in a lot of situations. There should be more of a society or governmental response. You're breaking the law if you do that, rather than up to one poor person who's stuck trying to enforce social norms or the store's own policy. So I think, I totally agree with what Professor Yearby was saying. We need to kind of funnel resources to these folks, calling them essential, but then not giving them the essential protections they need is really problematic.
Yeah, let's see. I had a question from the chat, and the chat says, with no business travel, less or unavailable personal travel, is it fair to expect Uber or Lyft to provide employer-type benefits? It's at least worth mentioning, especially if the rates had to be raised or might no longer be competitive. Are there stair-step methods that take into account the business stress these organizations might feel? So great question coming from the chat. So actually what's interesting, I've gotten this question a couple of times. What's interesting is that Uber and Lyft in some ways have, they've seen business travel certainly drop off. You think of Uber and Lyft as your ride to and from the airport. Yes, that business has been down. But on the other hand, they've picked up quite a bit of work, because there are many people who don't feel safe taking public transportation right now. And so they feel better, safer if they're in a ride share and they're just with one person, maybe they got the window open, they're wearing masks, but they feel safer. And so those businesses have taken a hit on the business travel aspect, but they've picked up people who used to take public transportation and no longer feel safe doing so. So as far as a stair-step method or something in between, that is what is on the ballot in November, I should have said, in California. What the rideshare companies, and they've been backing this ballot initiative, what they've been saying is they want to create a third category in between employees and independent contractors. So they're not saying that this should be independent contractors. They're actually kind of staking out a third category. And I've done some writing and researching about this because other countries like Canada and the UK actually have this third category as well. Now, of course, the devil's in the details, and it gets into questions of how you define the third category. If you define the third category in a way like Canada does that looks a lot like an employee, then you get the same benefits. But if you define it in a way where people aren't able to access these benefits, then we're back at the same old problem, I think, of workers trying to access benefits. So I think that is a question. And, obviously I think the rideshare companies are struggling a bit in terms of finding their feet with a business model, having compliance, paying workers appropriately, minimum wage and other issues. But they really need to do that, because that's not really an exception in the law, just that you're having some difficulties so you don't have to pay minimum wage. So, I do think they need to figure out a way to become into compliance with some of these laws. All right, so that was the question from the chat. I have another question here. This one is for Professor Bodie. The question is, can employers terminate an employee as a result of some data that they acquired?
All right, so does that mean in terms of, so the general rule is at will, right? So the question would be, would it run afoul of any of the statutory or common law protections to fire someone? If someone tested positive for coronavirus and you fired them for that, that would, I don't know that would fall directly under the ADA because it wouldn't necessarily be a disability. On the other hand, if you fire them because they informed you about the coronavirus, that feels to me like it would be problematic. But I'm not, and I haven't heard of people getting fired for testing positive. If you fire people for going to bars, again, you might run afoul of the off-duty activities law, but there are often exceptions in the off-duty activities laws for legitimate business interests. So if the employer says, I don't want you going to places where you increase the odds of getting the coronavirus, again, that might seem invasive, right? Can an employer say to employees, you have to wear masks off duty? I would think a lot of employers would like to say that. Again, that seems invasive. I haven't seen those test cases come up, so I don't think an employer would likely get into trouble for saying that. Now, the employer might get into trouble for spying on its employees to kind of determine whether they're actually complying or not. If it's just basing it on kind of actual evidence that's acquired not through invasive privacy busting methods, then it might be okay. But that's actually an interesting question. I hadn't thought of the question of, if you get the coronavirus, can you be fired? That wouldn't seem problematic. I'm seeing another question real quick. Can an employer require a tracking app for contact tracing? So in those states where the employer has to get an employee consent to monitor the employee, then you would need employee consent. But the problem with employee consent is that in an at-will regime, you can say, well, do this or you'll be fired, right? Some European jurisdictions actually say, well, that's not real consent. We're not going to count that as consent. The employee has to be able to say no and keep their job. But I haven't seen that a lot in U.S. Common law yet. So, or in statutory laws like the state level. So it's a problem, right? It's a problem.
I think you're getting one more question. Suddenly we've gotten a flurry of questions here on the chat about the off-duty conduct statute only applying to legal activity.
Right.
If
so
they don't wear a mask.
Right. If you're required by law to wear a mask and you don't wear a mask, I mean, again, the general rule is at will, right? So the employer would have to come up with some theory for why what they're doing is protected. And if it's only legal activities off duty, which has raised some interesting, kind of to get off topic a little bit, raised some interesting questions in the marijuana context. It's still illegal under federal law, but it's legal in a lot of states now. But if it were illegal, in fact, to be going out in public without a mask, then one could be fired for that under at will, as long as they're, if obviously as a law professor, I could add a lot of facts to the hypo, right? So if only certain groups of people are being targeted for that sort of penalty, then that might be discriminatory for the fact that these folks are being targeted. But sticking cleanly to that, that in and of itself would not be problematic.
Okay, we've got some questions here in the chat. Thoughts about constructive discharge. If a company failed to recall this one's complicated. A Sarbanes-Oxley whistleblower who was furloughed due to COVID, but other employees did not, and the employer is claiming it's neutral decision-making.
Yeah,
I don't know if anybody wants to take a guess at that one.
I would just say we don't. I mean, again, as law professors, we can't really opine on specific cases, particularly when we don't know all the facts. It would seem like if a whistleblower was being further retaliated against, that would seem to be a violation of the anti-retaliation provisions of Sarbanes-Oxley. But
yeah, I think we need more facts. It was, feel free to get in touch after this panel. So with that said, I think we're reaching really the end of our time. That may have been the last question, in which case I'm gonna go ahead and ask Mike Ruiz to come back and say thank you to everyone who's attended.
Yeah, well, like Miriam said, looks like it's the end of our time together today. And I want to take a moment to thank everyone and the panelists for making the time to share their expertise and experience with us. It's been extremely insightful and very timely, so thank you for that. And also thank you for everyone that joined us today. We hope you enjoyed the panel, and we will be following up with an email with a survey and a CLE certificate for you. We hope you consider joining us next Tuesday, September 8th for our next installment in the series, which is highlighting health law and policy during the pandemic. A link to register will be included in the post-event email. And lastly, if you'd like to support the WEFL Center for Employment Law and for future CLE opportunities, there'll be a link to give in the email as well. So thank you again for joining us, and I hope you have a great rest of your day.